Justice in Motion, courtside with Jared Jones.
Yeah, this is again, can you believe it? Time flies. Last week we were having a conversation with Jared Jones about just kind of what the legal framework looks like in South Africa. And today we are back for episode 2. Jared, how are you doing?
Sam, fantastic my side, and I hope you're well as well.
Yeah, you know, Jared just kind of blew us away with his music knowledge. I think he was a bit of a clubby back in the day. You know, one of those club guys between the books and whatever. Okay, so every week we have this conversation, and our mission is simple, Jared. Our mission is to do what?
Our mission at the moment is to empower the local community, you South Africans out there, with the knowledge to help you in all legal matters.
Yeah, and something that's quite interesting, and here's the weird thing. I don't know if it's a thing that everybody will experience in their lives, or someone, I don't know what the data or the stats around it is, but this idea that, or maybe I should ask, what is a constructive dismissal? Because that's what we're talking about today.
All right. Sam, so constructive dismissal is effectively started where, or it's dependent on two elements. Firstly, where an employee resigns, and secondly, that resignation is predicated on wrongful conduct of the employer. That is effectively it in a nutshell.
Wow. Wrongful?
So it'll be wrongful conduct.
On behalf of the employer.
Correct. So the employer goes through either a campaign or a series of different actions which leave the work environment so intolerable in terms of 1861E of the Act, the Labour Relations Act, so that the employee has no other reasonable alternative but to resign.
Yeah, and that's quite interesting. And that could be in terms of, for example, resources, micromanagement, creating toxic work environments. It could be a host of things, right? Absolutely.
This can go from anything from a very unreasonable manager to active steps to change the key performance indicators of an employee and their work function, effectively slowly working them out of that workplace.
Yeah, I know you've curated a whole bunch of, in terms of talking about the resignation illusion, but just on the back of what you're saying, what does the data tell us? There was this old saying that goes, people don't leave jobs, they leave people. It's people that create environments where others can't thrive or work.
Well, that's inevitably the case. I think in any kind of situation in the world of labor, it's all about relationships. It's whether your employee is doing what they're supposed to be doing, whether there is friction between the employer and the employer. Those are definitely elements that are paramount in any relationship in the labor sector. Now, with this particular situation, it's incumbent upon the employee, the onus as they call it. The duty falls upon an employee to prove this particular case. It's not
Which can be difficult.
And that is absolutely difficult because it requires evidence.
Yeah.
So again, we'll get into that further in this segment, but the point is they bear the onus of proving that this situation was rendered intolerable.
Yeah, that could be quite interesting. So let's maybe go back to the beginning. What is the resignation illusion?
So the resignation illusion, effectively, there's 2 points, I think, of departure I'd like to just clarify for our audience.
Yeah.
Firstly, every person that resigns does not have on the face of it a case for constructive dismissal. For an example,
very important.
Yes,
very important.
So please, for those of you listening today, don't go out there without legal advice directly to the CCMA with this. So if a person resigns in an attempt to avoid reasonable and fair disciplinary action against them, or dismissal, and they resign, and then they try and bring a case after the fact, that may be a problem. It depends on the facts, but in the ordinary course and scope, that is not constructive dismissal. Again, it would be dependent on the grounds.
It's so important what you're saying, Jared.
Yes, so again, this is an incredibly difficult case to prove. So that onus element is quite important. Then we look at the definition of what is intolerable in this circumstance. So the onus portion is what they is dependent on what they call Section 192 of the Labour Relations Act. Now we go back to 1861E. So the case law alludes to the fact, and this is the South African Rugby Players Association case, 2008, that alludes to this as an LAC case. The intolerability is predicated on two different points. Firstly, the conduct of the employer, not just subjectively, but objectively speaking, the reasonable person, the hypothetical we've created in our law, whether from that perspective, not just the conduct, but the impact on that conduct on the employee would render objectively that work environment so intolerable that the employee has no alternative but to resign. And then there's, of course, the aspect of the options available to the employee. Again, what has to be indicated is it doesn't have to be the only option, but it's the only reasonable option. And again, that has to be weighed very carefully against your grievance procedures, your CCMA disputes, that you can bring all other steps that reasonably could be brought before that resignation process. And again, it's also about the resources internally to deal with a grievance, what they deal with in that grievance, whether there's time to deal with a CCMA dispute before they bring the axe down on the employee. These are all factors which have to be carefully considered. But again, in my opinion, it's a duty upon the employee to take steps to defend themselves in that circumstance and take what reasonable recourse you can do so that you not only can show that you've taken reasonable steps, but to show a paper trail so that you can use that in in a constructive dismissal case if you do resign as a result.
That is very interesting and deeply complex. And often the things we don't think about because we are emotional at the time that
Yes.
it dawns on us that the environment is now toxic. Because I think the question I wanted to ask you was, this is over a period of time. This doesn't happen on a Wednesday and by Friday you are fed up, full of the situation. This is over a protracted period of time, right?
Absolutely. Now, it depends effectively, depending on the employee, depending on the turnaround times. One of the strategies that may be employed by an employer, whether reasonably or not, is disciplinary action coupled with or without poor work performance review. Now, the usual process is if there is a standard that's not up to scratch, you'll start the poor work performance procedure. Usually is about 2 or 3 meetings where you identify the problem, you look at a strategy and a turnaround time in which to remedy that, what assistance the employer can do, and then you go from there. Obviously, if that doesn't remedy over that time, eventually it's going to lead to a hearing. So that's how that would work. And then naturally there's the disciplinary part. So again, the poor work performance process could take over the pace of maybe 1 to 3 months, depending on the complexities of the matter, that entire process, or slightly more. And again, disciplinary processes, those have to be dealt with fairly expediently. But the thing is, when you're dealing with what may be a constructive dismissal case, that might happen fairly fast. And again, if you're looking at disciplinary conduct or misconduct by the employee, the important element for constructive dismissal is that the actions taken by the employee are not fair, reasonable, with merit, effectively. So you would have to look very carefully at the charges and the facts brought against you in all these circumstances by the employer. And again, like I say, my strategy and my recommendations to the public is that if you start seeing this change in demeanor, in tone with the employer, I would say seek advice first and foremost. Identify to that person, legal consultant or attorney or HR consultant, not within the company, mind you, as yet, as to what the issues are and how to go about it, because your strategy is very important.
Can I ask, the reason you mentioned not within the company is because, let's say, for example, most people would feel that that's an HR potential thing. I would go to HR and say, guys, something is not right. But HR is beholden to the company, or are you saying that HR, or where would you go if you initially felt the environment is changing, that the relationship dynamics between you and your employer is changing? Okay,
so where that dynamic is starting to change and we're starting to see the starting points of constructive dismissal, HR is indeed a branch of or a representative of the company. There is a level of
human resources for staff.
Correct. Yes, there is a certain level of impartiality, but there's also informally, where the bug in the room effectively is they are employed by the employer. So understand the risks, So I would firstly obtain outside legal advice and then execute a plan on that with the assistance of HR, because it's important to use the grievance procedures in the company. Escalate it informally, formally, to the CCMA if none of those work.
To get an outside perspective.
Correct.
Because you don't understand, and we're not saying this for a moment, but you don't understand, human beings are human beings. So you don't understand the dynamics between the HR person you're complaining and maybe your senior. Maybe they are drinking buddies. Maybe they are friends. Maybe
This is exactly the challenge that we face. And again, also, it has a dual effect in that you can objectively monitor your conduct in the situation as the employee. There are circumstances where the employee is indeed at fault. For example, I was talking about this earlier with a colleague, where a manager and an employee have an altercation and a fight in the workplace. Now we've got a different dispute. So we might have what might be deemed as fair and reasonable conduct by the manager, a reasonable and lawful instruction which is outright refused by the employee. The manager gets upset. Unfortunately, human emotions get involved, which I don't recommend in either position, and it turns into an all-out altercation, and that would inevitably lead to some sort of disciplinary steps being taken by the employer. So the main point is, one, avoid those conflict situations. If there is a challenge with an instruction, ask for clarity. Escalate the matter further. If there is a lawful issue, take it to HR. The point is, you do not lose your composure in a work situation, because that kind of conduct can go against you as an employee in the form of insolence, or worse, gross insubordination, the one charge that quite often comes up in disciplinary matters. So again, it's a self-check. And it's also a check against the conduct of the employer, whether it's fair and reasonable or whether you need to start taking steps.
Very important.
And
because some of us are hotheads in that moment.
Absolutely.
Some of us are like, you will not tell me,
Again, much like I mentioned to most of my matrimonial clients, and it applies equally in that sector, rather than lose your temper in a situation, calmly excuse yourself and walk away and deal with it. Compose yourself, either deal with it in a calm manner, and if you can't deal with it, get a facilitator or a mediator. In this circumstance would be HR, to facilitate that process so that it doesn't become a mudslinging match. And then the next aspect what I would recommend, just as a strategy, and this is probably one of the most important parts of this process, record everything in writing.
I was about to say,
again,
document.
Correct. So if you're going to have a meeting with or informal chat with one of the managers behind the scenes, send an email to them recording the contents of that meeting. If you're going to have another process with management, record that again, the contents and what the outcomes were. If there's disputes, so be it. But again, you are now starting to create a paper trail, which you may be able to use later down the line to show that you took reasonable steps. Again, if there's a lack of clarity on the reasons for a particular step and they just brush it off, now we're looking at CCMA action. If there's not sufficient time between the hearing of that CCMA dispute, unfair labor practice, and of course the internal processes, at least you can demonstrate you took the steps to what was necessary to protect yourself, and that resignation was the only way out.
Yeah. Let's very quickly talk about Naledi's story. I think we've almost touched on Naledi stories in many ways, right?
All right. So just for the audience, if I may, Sam, if you can just reiterate the Naledi story for them in brief.
Yeah. So Naledi was a digital marketing manager at a tech firm in Cape Town when a new CEO took over. Her responsibilities were quietly reassigned. She was excluded from strategic meetings. Her KPIs were changed mid-quarter. She received her first negative performance review. Repeated attempts to address it were dismissed with phrases like adapt or move on. And over 3 months, she began suffering from panic attacks and resigned.
All right. So, Sam, in this particular situation, there is a clear unilateral decision on the employer to either completely change a position on the face of it, and worse, possibly an active attempt to move out of the workplace. Now, where there is a lack of consultation on the change of KPIs, there has to be consultation, reasonable consultation with the employee, because they were employed for a particular purpose. Again, in the absence of that, that is unfair labor action by the employer in unilaterally changing those conditions. Now, again, this may usually take place in the process of retrenchment processes, but again, there's a consultative process there. Again, it must be shown that they have done that process. Otherwise, this is a unfair labor practice, and the first thing I would do is raise that grievance with the employer, like we've indicated, failing which we take it to the CCMA.
Yeah. And so interesting that you mentioned that, Jared. I think sometimes the challenge is when you're working for families or when
Yes.
you're working directly with bosses, you'll find out that over a period of time you are required to do more, and it's not necessarily covered in your contract.
100%. Again, I think what is vitally important here is to record and clarify exactly what your duties are, what the amendments are. If there has been a proper engagement on those processes, then so be it. And or where it's legally justifiable in terms of legislation. Let's take, for example, a bookkeeper and their slight amendments. But again, consultation is vitally important for an employer. So if you're going to run those processes, consultation first every single time. If I were the employee and I had little recourse within the company, more particularly if there's now this aggressive stance from a particular employer, this is where I would engage an attorney or trade union or the like to send a letter of demand to the employer, setting out the terms. These are the issues. This is how you've behaved in this situation. You have certain amount XYZ time in which to remedy that particular problem. Otherwise, we're taking it further. Again, from a human perspective, there is absolutely no reason why an employer or a manager or anybody has the right to scream at another person or treat them with disrespect. So where there's any of that form of disrespect or unilateral changes, it's important to record, escalate again to formal processes like or forums like the CCMA, and or take such further legal action as is necessary. And again, I would take advice from an attorney whether civil or criminal remedies are necessary, the latter in extreme circumstances of misconduct that is necessary to protect your rights.
Finally, as we wrap up, tips for both employee and employers.
Excellent. So let's start with employers. I think we've left them out in the dark long enough.
We can talk about them at some other point. Yeah.
So employers, one, run fair processes, run consultation, record, and obviously, as much as can reasonably be acquired in a company, have independent, impartial parties running or facilitating your different processes, and of course, address reasonably and fairly any concerns raised in grievance proceedings. That's for the employee. For the employer, it would be act calmly, de-escalate in terms of aggravation, record all conversations, escalate it within the HR policies of the company, obviously, like I've said, subject to your own advice where you can obtain it. Run those processes. If exhausted, look at options like the CCMA or further civil remedies where necessary. And of course, make sure that you do consult with attorneys so that you ensure if you have to resign, that it is a port of last resort. And again, what is also just a bonus point here is that your intention to leave the company must not have been pre-existing. So the usual test, so that's quite an important one. Yeah. But for this particular conduct, you would have indefinitely continued with the company. So bear that in mind first and foremost when engaging with these processes.
Very, very important. Jared, as always, masterclass, and I'm sure lots of us who are going through these challenges, you've at least illuminated a path for us a little bit in terms of what the next steps are. How can people get hold of you if this is resonating with you and you need to engage with an attorney who understands these processes? Where can they go?
Okay, so they can Google us, Jarrett Jones Attorneys. We are situated at Edavale, or you can visit us at our website. It's www.jdjattorneys.co.za.
Justice in Motion, cutting through legal noise, one truth at a time, with Jarrett Jones.